For this answer plan, we'll be looking at question 3 from chapter 4. A return to the pre-Human Rights Act method of protecting human rights would be damaging to both the protection of basic liberties in domestic law and the UK's relationship with the European Convention on Human Rights. Analyse that statement with respect to recent proposals to repeal the Human Rights Act 1998. This question obviously refers to the recent proposals of the Conservative government to scrap the Human Rights Act 1998 and replace it with a British Bill of Rights. It also asks you to comment on the wisdom of that proposal, suggesting that such a move would cause disadvantages to our human rights law and our relationship with the European Convention. This question will be very popular in the next year or so whilst the government decides how to proceed on this issue. It requires knowledge of the relevant law, past, current and proposed, but also an appreciation of the various arguments for and against the proposal. So let's talk through the answer plan from the book, indicating to you how and why that plan was put together in the way it was. This should enable you to understand the nuances of the question and the thought processes of the person who set the question and who will be marking your answers. This introduction will set the tone for the discussion, giving you an opportunity to display your knowledge of the proposals and your appreciation of their controversial nature. At this point, you can outline the content of the proposals and refer to the reasons behind them, that the government wished to free us from the constraints of the Convention, the European Court of Human Rights and European human rights law, and allow us to adopt a Bill of Rights based on British values and domestic law. You can include the basic proposals, but don't go into any detail as the question requires you to consider other issues. The pre-Human Rights Act position needs to be considered because the question refers to a return to that system and the disadvantages of doing so. You need to outline the basic principles of human rights protection before the Act was passed, but more importantly, highlight, through the use of cases and other examples, the merits and demerits of that system. This will allow you to appreciate why the Human Rights Act was passed, and to draw conclusions as to the truth of the statement in the question. This section will allow you to explain how the Act sought to improve the traditional system and how domestic law could become more compliant with the European Convention. Now, with the use of case law, you can explain the central provisions of the Act, the use of Convention case law, the duty of the courts to interpret domestic law in line with Convention rights, and the power to issue declarations of incompatibility. You should also explain how those provisions made our law more consistent with European human rights law. This is the central aspect of the question: which system, in reality, is more effective in protecting human rights and ensuring that we comply with both international standards and our own standards of justice? When tackling this part, you'll have to consider the government's arguments: state sovereignty, the power of government and parliament over the courts, with the alternative arguments that repeal will dilute the efficacy of human rights protection and endanger our reputation in Europe. This should then allow you to offer your opinion on the truth of the statement and the wisdom of the government's proposals.